Hello and welcome to today's event. It's the GIGAEurope EU Presidency event on navigating the digital ecosystem under the Digital Services Act. Now, it's a very timely discussion we're going to have today, as we know that building on the 2000 e-commerce directive, the Digital Services Act is one of the keynote pieces of legislation that has been put forward by the European Commission to transform the entire digital ecosystem and Europe's digital economy, as these are one of the things we need to look at in building back better and coming out of the pandemic. So this is going to involve a very wide range of actors, from online platforms to connectivity providers. And we're going to be talking about that connectivity element today and talk about how we can have these trustworthy providers for internet access. This is, as I say, part of the EU Presidency event series. It's the GIGAEurope's second event on this platform. So we're very pleased to have it organised with the support of the Slovenian Government Office for Digital Transformation. We will have a keynote speaker, we will have some questions, but I do want you, the audience, to put questions to our panelists as well. So please do use the Q&A function. It should be at the bottom of your screen, and I will try to get through as many questions as is possible in the next hour. But now, to tell us a bit more about GIGAEurope and about the event series, I'm very pleased to welcome Irene Varlan, who is the Managing Director of GIGAEurope.
Thank you, Jennifer. Good afternoon, everyone, and welcome to the GIGAEurope EU Presidency event, Navigating the Digital Ecosystem under the Digital Services Act. My name is Irene Varlan. I'm the Managing Director of GIGAEurope, a trade association that brings together private operators who build, operate, and invest in gigabit networks that enable Europe's digital connectivity. The uncertain times we live in still force us to only meet virtually. As connectivity providers, we continue to play our part to keep societies connected. From home working to schooling to chatting to our loved ones, we fulfill our need to stay together. The rotating EU presidency provides fresh ideas and new priorities to Europe's digital strategy. As GIGAEurope, we find it important to engage in a dialogue with the EU presidency and work together to build Europe's gigabit society, to make Europe a digital leader. Today's webinar is the second of a series. As Jennifer mentioned, our EU presidency events focus on each presidency of the EU Council, inviting them to share their views and priorities on the EU digital strategy, as well as engage in an open dialogue on the progress of topical files. The event subject, the Digital Services Act, though mainly aimed at online platforms, impacts the entire digital ecosystem, in which connectivity providers play an important role by providing trusted internet access to the digital world. While the spread of illegal content is a concern to us all, a crucial element of trusted access and broad participation in the digital economy and society is that users need to know that their connectivity provider protects their private communications when accessing the internet or uploading content. Internet service providers do not proactively monitor content on their networks, which reflects a principle already contained in the 2000 e-commerce directive that prevents member states from imposing a general traffic monitoring obligation on network providers. Connectivity providers do, however, act swiftly against illegal content upon notification or court order. They cannot be held liable for online content as long as they stick to the mere transmission of user-generated content. It is reassuring to see that the ongoing discussions on the GSA are indeed confirming the liability regime set in the e-commerce directive. However, it is important that the GSA's due diligence rules for online platforms do not spill over on connectivity providers. That would be disproportionate and upset the delicate balance between combating illegal content and protecting the rights of businesses and users in the digital ecosystem. Allow me to congratulate the Slovenian presidency with reaching agreement between the member states on what is likely to be one of the most important legislative initiatives at this point in time. I look forward to the discussion on how the DSA should find a balance between proportionate rules and protecting fundamental rights in the digital ecosystem as we move towards the final stages in this decision-making process. I am deeply honored and grateful to welcome all of our distinguished guests today, policymakers alongside academia and industry representatives. I now hand it over to our keynote speaker, Mr. Peter Geršak, State Secretary, Slovenian Government Office for Digital Transformation. Thank you.
Thank you, Irina. Thanks to the organizer, to all of you. So, dear ladies and gentlemen, good day. First, allow me to thank you for this event, for this webinar. It's giving us an important opportunity to discuss really crucial values for 21st century, I would say. So at this point, highlighting the meaning of information society, my first conclusion would be that today digitalization and digital transformation is not a matter of choice, but is an urge and expectation. And from that perspective, I believe we all share the opinion of the importance of the online ecosystem for our everyday life, actually, yeah. And in its digital nature lays our ability and responsibility to co-create this new digital world, where new digital economy is a part of it. So the most powerful actors of today's digital economy are actually online platforms. They cut out actually middlemen and provide more direct channel between consumers and sellers, creators and users of the content and services, thereby actually causing this disruption actually in a range of sectors, from the media and communications to e-commerce and labor markets. And the disruptive power of intermediary platforms is changing our world, I would say, yeah. So the platform ecosystem is highly centralized, with a few commercial actors in control of information flows, content, services, and goods, recommendation, ranking, and rating systems. These actors are actually able to bend entire markets and have a huge societal impact. Although citizens and businesses are dependent on intermediate platforms, they have actually very little insight into the functioning of these, let alone the ability to have a say in it. So by reorganizing social activity in the interest of data and value extraction, platforms business model can have a large unintended consequences for society and for democracy as well. For example, treating information as nothing more than a commodity has degraded public debate by amplifying harmful misinformation and disinformation. We can conclude that the digital single market of intermediaries is not functioning as it should. It is not fair for a great deal, for too many stakeholders. There is not a level playing field for smaller platforms, and innovation on the internet is actually hampered a lot. So therefore, a year ago, European Commission proposed the Digital Service Package, including Digital Services Act and Digital Markets Act. Together, so DMA and DSA in short. Together with the DMA, the DSA proposal is at the core of the European digital strategy, shaping our digital future, and has been one of our top priorities as well during the presidency. It will provide European consumer with fairer and more trustworthy online environment, as well internet businesses with more legal certainty. The DSA has the potential to restore citizens' trust and increase consumer protection online by creating a harmonized EU legal framework applicable to all intermediate service providers which are offering their content, goods, or services within the EU. So the DSA proposal is an important element contributing to a more harmonized internal market and to a safer online environment, and particularly by increasing and clarifying a common set of responsibilities for online businesses providing services in EU, and in particular for online platforms like social networks or marketplaces. So the underlying policy objective are to keep users safe from illegal goods, content, or services, to protect their fundamental rights online, to restore trust in the digital space, to exploit the potential of the online platform economy while protecting our democracies. If I can simplify it a bit, we are actually rewriting the rules on the internet use to make it safer for the users and fairer to businesses, with more legal safety and more liability and accountability of the intermediary digital platforms. I think that the proposal is a great opportunity to increase European global competitiveness as well. Modern and clear legislation that balances the interest of the various stakeholders will create more transparent, fairer internet environment, not only for European users and for European businesses, but also worldwide, globally. Digital service package will contribute, as I said, to safer digital space in which the fundamental rights of all users of digital services are protected, and will harmonize the rules for the functioning of the digital internal market by setting standards for the creation of competitive, non-discriminatory, responsible, and fair digital markets. In this way, it will ensure a level playing field and more opportunities for all businesses in the EU digital market, and consequently more choices for consumers, fairer and more competitive pricing and prices. I believe that the key for success of the DSA is the use of the balanced approach with rules based on regulation and co-regulation. And here I mean also including self-initiated measures, while also still counting on the societal responsibility of the intermediate platforms. With the aim of combating illegal content, the DSA regulates the obligations of intermediary platforms only for illegal content and continues to leave harmful but legal ones to self-regulation. It only touches on them briefly in the arrangements for the terms and conditions set by the platforms themselves. In the case of illegal content, the DSA only determines the obligations and the model of communication between the actors, but does not determine the illegality of individual types of content, which is actually understandable since the case of latter, the DSA would unacceptably interfere with the national legislations, meaning that actual negotiations of such would be impossible. The DSA anticipates remedies for inappropriate moderation of harmful but legal content by risk assessment and risk mitigation measures, which are applied in reaction to such systemic infringements. I believe that in this case, we can continue to count on societal responsibility of the intermediary platforms. Otherwise, the legal binding moderation of harmful but legal content could be understood as actually overregulation. Yeah. So I believe that the key point is in a balanced use of two principles. So first one is not to over remove the content, as freedom of expression could be affected. And secondly, not to under remove the content, as the effectiveness of the fight against illegal content could be affected. Yeah. So our task is to enact the DSA regulation, which will be both efficient and in fight against illegal content, illegal services, and illegal goods on the internet, while not hindering freedom of speech. Together with other member states, the Slovenian presidency did its utmost to resolve the issues where the differences between the member states were greatest. Yeah. So accordingly, we managed to reach a general approach, as Ina mentioned, on the DSA on the Compet Council a week ago, actually on 25th of November. And this actually was our goal at the beginning of the presidency. So we are very, very happy that we have achieved it. And we believe that this way we gave the French presidency an opportunity to start the trialogues in the beginning of the next year. So we believe that the end of the French presidency, actually in the next half of the year, the legislative procedure should be finished and the new DSA regulation actually adopted. So all this in the benefits of the European citizens, digital economy, the whole European society, and as well globally. So many thanks, and Irina, back to you.
Well, thank you very much indeed for that, Peter. We really do appreciate you taking the time to set out so clearly about what's happening and what you think the priorities need to be. Now, as you're aware, we have some great panelists joining us for today's discussion. A couple of our panelists have already got questions that they'd like to put to you. So I want to bring in first Matthew Allison, the Senior Public Policy Manager at Vodafone Group. Matthew, I know you've been listening closely there to our keynote. Perhaps you could tell us what you thought or give us a brief question to put to Peter, please.
Thank you, Jennifer. Yes, really interesting comments and reflecting also on the hard work which has been done over the past year. And I think already we're seeing some excellent progress on this file. My question was, would the Secretary of State agree with the need to ensure that the due diligence obligations under the DSA are proportionate and effectively targeted at those service providers that pose the greatest risk to EU citizens?
Thanks for the question, Matt. So actually, yes, we agree that it is of the utmost importance that the due diligence obligations under the DSA should be proportionate and that should be based on the risk assessment for the EU citizens and the economy. We should stick with the conclusions of the impact assessment, actually, of the European Commission. And in pursuing the public interest, we can only interfere with the freedom to conduct businesses to the smallest extent possible. I would also like to reiterate the fact that the final text approved with the general approach is the compromise, yeah, and the result of the complex negotiations between member states. So the possibilities to improve the final text will also come in the future, yeah, will come during the French presidency, will come during the trialogues in the beginning of next year. So that's actually my answer to you, Matt. Thanks.
Thank you very much, Peter. As I said, we have another question for you from our panelists. So I'd like to bring in Sally Broughton-Micova, who is a research fellow at the Centre on Regulation in Europe and a lecturer on communications policy and politics at the University of East Anglia. Sally, again, I'm going to hand the floor over to you to ask your question.
Thank you very much. Thank you very much, Mr. Geršak. I appreciate very much that you highlighted the need for that important balance between protecting freedom of expression by not over-blocking and over-removing and protecting people from speech. And another angle on freedom of expression is the positive obligation to states to help enable expression, and media pluralism is often seen as part of that. I have argued for media pluralism to be considered, and I've seen some amendments that have been tabled in Parliament to include media pluralism as one of those risk areas that very large online platforms would have to look at for risk assessments. What do you think about media pluralism, and do you support any of the efforts to include that?
Thank you very much for the question. Very interesting one. So my answer would go in a way that at the meetings of the Council Working Party, we already coped with the ideas to introduce without prejudice clause to measures taken at a national level to promote media pluralism. However, we think that there's actually no necessity to do that. Namely, the e-commerce directive in Article 1.6 states that the directive does not affect measures taken at a national level in respect to union law to promote cultural and linguistic diversity and defend media pluralism. So this provision will be still valid after the adoption of the DSA. And it has therefore actually not been considered necessary to include similar provisions in the DSA. So from the classical media and from some member states, we received suggestions to provide prohibition for very large online platforms, VLOPs, to interfere with legal editorial content based on their terms and conditions. So this idea is based on the conclusion that VLOPs have increasingly become spaces of public discussion and indispensable distribution channels for media service providers. So defending to defend media pluralism, the DSA should actually prohibit VLOPs from interfering with an editorial media content based on alleged violations of the TNCs without prior consultation with the media service provider. So while to a certain extent we could align our understanding of the problem with the underlying arguments, we are still currently in the role of the presidency member state to the Council of the EU. So we cannot actually take a really hard position on this issue, as I'm sure you understand and you know that. We anyway still believe that the DSA is provided soft approach to such issue with the risk assessment and risk mitigation measures of the platform, and then possible European Commission decision with the corrective measures to actually eliminate systemic infringement will be capable to efficiently cope with such challenges. So nevertheless, as it stands for now, at the Council Working Party meetings, there were not enough support to go with the proposal. However, as previously mentioned for Matt, there will be opportunity for proponents to secure enough political support in interinstitutional trialogues among the Council of the EU, European Parliament, and European Commission. So that's response from my side. Thank you very much for the question.
Thank you very much indeed, Mr. Geršak, who is the State Secretary of the Office of Digital Transformation at the Slovenian government. We do appreciate you joining us and representing, of course, the Slovenian Council today. So thank you indeed for that.
Thank you very much.
Let me turn now to our final panelist. As I said, we have got a panel for you today to discuss this issue, that has been set out very clearly so far. We've heard from Matthew Allison, who is from Vodafone, representing industry. Sally Broughton Micova is obviously from the University of East Anglia, representing academia, and joining us from DG Connect as the Deputy Head of Unit in the Digital Services and Platforms Department, it's Irene Roche Laguna. Thank you very much, Irene, for joining us as well to represent the policymakers side of things. So let me give the floor to you first to tell us what you think is the role, if you like, of the connectivity sector in content moderation, or how you see the connectivity sector fitting into the overall ecosystem, as well as perhaps your reflections on what you heard there from our keynote.
Yes, thank you very much, Jennifer, and good afternoon, everyone. I would like to start thanking the keynote speaker for the role that the Slovenian presidency has played in the last 5 months, because it has really been amazing how it has brought the Council from a wide divergence of views to a fast agreement and a balanced solutions from our perspective. And also having in mind that we are talking about a very politically very sensitive instrument. We knew when we tabled the proposal 1 year ago that it was important and necessary to have discussions with the member states and with the parliament, but we are also positively surprised that the council has come to a general approach in less than 1 year. So now coming to your question, indeed, connectivity, the connectivity sector is very much affected or interested in a balanced approach in the DSA. First and foremost, because we are taking over the rules on the liability exemption from the e-commerce directive, which has been key for the development of the internet sector. Everybody has in mind online platforms, as the keynote speaker has shown, but the truth is that the internet is more than Google and Facebook. It is much more than that. And we have the whole internet infrastructure that allows us to have access to all the content that our families and friends share every day. So it was for us essential to ensure that these rules that are 20 years old and even some national courts were saying, well, they might not be fit for purpose because the internet of today is different from the internet from 20 years ago. We took, in my view, quite a courageous stance to put these rules again on the democratic table. And personally, I'm very happy to see that the Council agrees with the Commission that these rules are indeed fit for purpose. So for the connectivity sector, the liability exemption remains for mere conduits. And we add a full set of due diligence obligations that becomes more detailed for online platforms and for those very large online platforms that are focusing all the societal impact of the internet. But the truth is that the connectivity sector also has to play their role. When they have terms and conditions that users have to agree with, they need to be transparent and they need to implement them also in line with the users' rights. And this might not be the first thing that would come to our mind for internet service providers, for instance, even though there are already self-regulatory measures that apply to content that is filtered out or that there are parental controls. But let's take, for instance, example of other infrastructure services like content delivery networks or domain name systems. We need to be sure that whenever they decide to moderate content, we know why and we know what are the consequences. So I will stop here on this first question.
Thank you very much, Irene. I want to remind our audience that you can use the Q&A function. I see a first question coming in already. But Matthew, before we get on to that, let me ask you, how do you believe it is best to achieve a balanced set of illegal content mitigation obligations? Is it a general risk assessment or is it a risk-based approach, or how do we break that down?
Thank you, Jennifer. I mean, I think absolutely the risk-based approach, as you mentioned, is the path that we would look to go down. And I think, sort of stepping back from your question, why I think this discussion is really timely and really impactful is that we have an opportunity to talk about some actors who will be affected by the DSA, the rules under the DSA, but are not always front and center in the discussion. I think it's fair to say that is the case for connectivity service providers, but also, as Irene just mentioned, there are many other actors in the internet stack, in the supply chain. You mentioned content delivery networks, DNS service providers, registrars, etc. There is a huge amount at the back end that's going on to enable us to consume and enjoy digital services and access and interact via online platforms. And it is a feature of this discussion that they are often in the background, and that's understandable because the biggest concerns that arise, the headline grabbing concerns, do tend to relate to the use of internet platforms. But I think we need to be careful when designing new rules and regulations that we don't regulate the whole internet as if it were a social media platform or an online search engine. And that's a really important principle to get back to. And I think in part answers your question. The way that we would suggest to go about that I think, Irene, this will very much flatter you, is to follow the approach which was proposed by the European Commission, which was risk-based, and set out to update and clarify the rules for all online intermediaries, and that would include mere conduits, caching services, hosting services, making sure that it's comprehensible, that it's in line with technological developments and European Court of Justice case law as well. But crucially, targeting the new obligations. And Irene, again, I think you mentioned a sort of sliding scale or ratcheting sort of scale of obligations with the more substantial kind of obligation of requirements sitting with the services that pose the greatest risk. And the criteria that the Commission's used, that we would tend to agree with, is to look at the size and the reach of online platforms. So that's a very basic metric that you can use. So active user numbers, the amount of people that are reached by certain content, and to use the basic criteria of, does the service disseminate material to the public, which the Commission has used as a sort of a tool to identify online platforms as distinct from traditional hosting service providers. And by using those two metrics, you can then target the obligations very accurately and narrowly at service providers that do indeed pose the greatest risk. And for us, this is the approach that we've been very supportive of since the Commission tabled its proposal, and have been trying to advocate that this is maintained as the file is amended by the different institutions. And pleased to say, looking at the work that's happened in Council and Parliament to an extent as well, those principles have been maintained. That is an ongoing process, and I think we can't ever just sort of take our eye off the ball. But it does seem to be a message which is filtered through to policymakers, and that's something we're really pleased about.
Well, Sally, let me get your thoughts on this in terms of how we assess risk. I mean, Matthew alluded there to, it could be the size of the organization, how much data they're using. It could be down to sensitive types of services that we're seeing. But I mean, we've also heard a lot of discussion and lobbying here in Brussels around the question of gatekeepers, with an awful lot of organizations very keen not to be seen as a gatekeeper. How do you assess that?
Well, it's important not to mix up the gatekeeping notion, which is in the Digital Markets Act, with the notion of video of very large online platforms, which is in the DSA. Now, I would say that if something is a gatekeeper that is public facing, then it's probably also a very large online platform. At the moment, the definition we have is just based on user numbers. But I think those things could be intertwined. I think what is quite important to focus on is this notion of systemic risk. Okay? And it was perhaps a risky policy innovation to try to transport that idea into this space. But it could work in tackling exactly this issue of the fact that there is this background that exists that isn't directly the public facing content services that we're concerned about. And we have to understand that the notion of systemic risk involves the system. It involves interconnectivity. And the DSA doesn't explicitly define the system, but it does explicitly deal with economic and societal harms, right? And it is defining very large online platforms as ones that serve a purpose in public debate and in democracy, et cetera. So we can envision what systems there are there at stake. Now, I think the way it would be very limiting if very large online platforms only looked at what was happening within their own space, within their own users, the measures that they put in place, because they're going to say, okay, well, we've got all these measures, we've got these kind of terms, we've got this kind of content moderation, etc. We're doing a good job, everything's fine, without thinking about the way their services are connected. And the harms that we're trying to prevent are big harms. They're public harms. They accumulate over a lot of space. They deal with public institutions, public systems. So I think a good example of how this kind of interconnectivity might work, particularly in relation to the kind of people who serve the kind of backbone of the internet. Think about zero ratings. Zero ratings are contracts where online platforms such as Facebook or YouTube don't count towards someone's data use on their mobile phone. And in a society where the socioeconomic level is such that a lot of people don't have fixed broadband at home, but rely on their phones for internet, and they might be on a lot of prepaid plans, which means that those people were likely to be overexposed perhaps to the kinds of services that have zero rating contracts, the ones that you can still use even when your data plan has run out, right? So for a lot of those people, the internet is Facebook, right? Or the internet are those few content services that they can still use even when they've run out of data. And so it isn't then that those internet service providers need to be, so affected by the DSA, but the notion of systemic risk is that those services that are assessing their systemic risk need to take into consideration that kind of a situation, that kind of interconnectivity, and into their risk assessments.
Well, Sally, I hear you on this question of it's come under the net neutrality debate an awful lot. I mean, it's generally perceived as a problem, if you like, more in the global south than in Europe so much. Would you say that, or do you think there's still pockets where we need to be paying attention to that in the EU?
I think there are pockets. If we're not thinking about this only at the national level, there's going to be pockets of society. And there are countries within the EU that have still large people who are operating on a lower socioeconomic level. In every country, there are large groups of people who are operating in the world where they're using prepaid phones with limited data, that they're doing everything off of it. I mean, even here in the UK, where I'm sitting at the moment, we do have a large chunk of the population that was dependent on their phones for their internet. And, you know, it isn't just an issue, I'd say, of the global south. Okay, thank you for the clarification. I'm going to look now at our questions. We've got a question coming in from Ryan Shada asking how the DMA and the DSA, it is indeed very difficult to speak about one without speaking about the other. How would they be applied to broadcast infrastructure for next generation hyperconnectivity in a non-discriminatory, politically neutral and cross-border way? I think it's quite a broad question to get into, but Matthew, would you like to tackle that?
Yes, as you say, it's quite a broad question, but I can definitely give you hopefully quite a brief and concise answer as to how we've interpreted both files. So starting with the DSA, because that is really the focus of this discussion. As has already been mentioned, we carry a number of legal obligations that are sort of legacy obligations from the e-commerce directive. So Vodafone is primarily a connectivity service provider, and we offer what's categorized as sort of a mere conduit service. And it means that when instructed to, we will block access to websites at the domain level. And the way that needs to work is that we need to be instructed and have a lawful instruction in order to do so. And this happens, you know, in the case of pirated content, particularly broadcasters are very keen to enforce their intellectual property rights. Also in relation to websites that are hosting terrorist material or child sexual abuse material, and we will block that website at the domain level. It's worth noting that we are quite narrowly circumscribed in terms of what we can do when it comes to blocking access to internet sites by the net neutrality rules that you mentioned, that mean that we can't block or throttle traffic. So we need that lawful instruction in order to act, and that's quite an important point, I think, to bear in mind when it comes to the responsibilities and the obligations of connectivity service providers. We do also offer some hosting services, primarily at the enterprise level, and there we would fall under the regime for hosting service provider, where we have to act expeditiously when notified of illegal material and make sure that it's removed. And I think the message that we put across is that, broadly speaking, that regime has proved to be very robust, very adaptable to technological change. And of course, we're looking back 20 years now since the rules were first cast, and the fact that they are still functioning, indeed, given how different the internet looks now, is, I think, a testament to the foresight of the policymakers at the time. But the real impact and the innovation of the DSA, from our perspective, is to move away from blocking at the network level, which we think is quite a blunt instrument, and have more responsibility sitting with the online platforms and the very large online platforms where material is disseminated to the public. And for us, that's a proportionate approach. It's a risk-based approach. So when we look at the DSA, we are very keen to understand how the due diligence obligations that are defined will impact us, and that's something that we will work with. There's 2 or 3 that stand out as being potentially areas that we will need more clarity and need to be refined to understand exactly how they would work in the context of a connectivity service service. I'm thinking, for example, the statement of reasons obligation, requirement to notify on suspicion of criminal offences. These are all things that will have to be worked out. But what we would actually, I think, perceive under the DSA is an opportunity to have a fairer allocation of rights and responsibilities across the ecosystem, with more of those obligations sitting with the online platforms when we're looking at things like risk assessment, risk mitigation. And ultimately, we think this should lead to a safer internet environment for our customers. One thing that is worth mentioning as well is that of late, Vodafone and other telecommunication service providers have been, to an extent, a victim of online misinformation. So there was a very coordinated and quite aggressive campaign, particularly in the early months of the pandemic, linking 5G networks with the spread of coronavirus, which is scientifically, complete, misinformation, and was having a real world impact, where people were reading this stuff, they were becoming skeptical about information they were receiving from, trusted sources of information, and actually it resulted in attacks and vandalism on our networks, harassment of our network engineers, etc. So, this stuff is not just in some social media bubble; it does have a tangible, real world impact. Now, we work with the online platforms to deal with this issue, but we do think that the DSA will forearm companies like Vodafone in the future with more effective means to ensure that misinformation is not promoted, and that you can actually puncture these bubbles of quite pernicious and harmful misinformation into the future. So I think in that sense, we approach the DSA as an infrastructure service provider first and foremost, but also as just one of the effective parties around having information spread online, which is which can be harmful. So I think I won't respond to the point on the DMA, because that's not really the focus of this particular panel. But definitely a follow-up discussion could be merited there.
Absolutely, and you can call it nonsense if you want to call it nonsense, Matthew. We know that.
Yeah, I was thinking of a ruder word, but I managed to rein it in.
Irene, let me come to you. I'm conscious of time is already getting away from us, but I'd like you to talk about sort of the country of origin model, and whether that's the best and most effective model, and why you might believe it is, or where there's room for improvement.
Yes. It's a very good question, and this was one of the main elements that we wanted to preserve in our proposal, and we are happy to see that the Council shares our views. The whole internet economy and the e-commerce directive is based on the country of origin principle, that when someone wants to provide services, online services, they don't need to establish in 27 different member states. They can be established in one member state and comply with one set of rules. Otherwise, it would become only affordable for the big ones, which is also the concerns that the Commission has voiced once and again, as regards national initiatives to give a solution to the increasing problems as regards online platforms, problems that we all agree that have to be solved, but we have to do it in a way that does not undermine the single market principles, which is at the end of the day the legal basis of the DSA and the legal basis of most of the competences that the Commission has and the European Union in the first place. So we designed a model that is based on the country of origin principle. Any intermediary which is in scope of the DSA has to be supervised by the country of origin, the country where it is established. Obviously, it does not mean that they could not create problems elsewhere. So we needed to create a detailed coordination framework where the country of destination could flag a problem to the country of origin, and also the Commission would play a role in this coordination in case of joint investigations that were needed, and also when there is a dispute that we need to settle and agree on the measures that are necessary. Now, because some of the platforms are bigger than some of the administrations in some member states, we already in our proposal, we thought that the Commission could play a role in an enhanced supervision system for those obligations that applied only to very large online platforms. It was a way to mutualize the enforcement and to mutualize the solution. So the Council has taken over this idea and has proposed to give even more powers to the Commission in this regard, to the extent that very large online platforms breach or conduct a systemic breach to the obligations of the DSA, which is something that all member states have agreed, and at the end of the day is a solution that is in line with the country of origin principle, because it does not put the country of destination against the country of origin and creates a sort of debate between member states, but the Commission, together with the board that would represent all member states, will bring a solution to those problems.
Well, I'm going to jump in very quickly with a question from Jameen Patel. Jameen, thank you for that. How future-proof do you think the current texts of the DSA are, given the focus on online marketplaces to protect consumers? Should we look forward to a revision in 5 years' time? Irene, I'll let you respond to that, and I'll get the opinion then of the others.
Is the question to me?
Yes, indeed. Go ahead.
Okay. Well, it is a very good question. We are the Commission proposal was intended to be already future-proof and setting the horizontal rules. Obviously, on top of those horizontal rules, there would be the possibility or even the need to have sector-specific measures. And this is something that the Commission 6 months later did for the product safety. In the general product safety regulation includes also specific rules for online marketplaces. So the guidelines that we followed when drafting our proposal was to do something that is as horizontal as possible and only as vertical as necessary. So there is indeed, there are specific rules for online marketplaces. And in order to ensure that traders, because in the specific case of marketplaces, there is a sort of cascade of different services that are provided. And then we have to be clear on the level of liability and responsibility for all actors in that cascade. So we consider that it was necessary to set general rules on the know your business customer obligations. But on the other hand, this is without prejudice to existing sectoral rules, which we have already in place in several sectors. And obviously, it does not undermine the European legislator to go beyond or to have sector-specific measures for certain problems.
Well, Sally, just briefly from you, how future-proof do you believe the current rules are, or the current proposals are?
The current? No, sorry.
I think, you know, every proposal aims, if not to be future-proof, at least to last for a good long time. I think we can see that even with the proposals that's being proposed now with the DSA, some of the fundamental elements of the e-commerce directive, which is 20 years old, are still being upheld. And I can see that things like the transparency obligations, you know, the due diligence obligations are probably things that will stand the test of time if we set these things in place now. And as Irene was talking about, we have sectoral regulation. The one that I specialize in is audiovisual media services, which significantly interacts with the DSA around video sharing platforms. The Audiovisual Media Services Directive is particularly aimed at content. It now includes video sharing platforms. It's going to go through a refit service in 10 years time, 5 years time. That's where you would deal with the more specific things related to, say, content platforms. There are other things. So, you know, I can see that some of the fundamentals here being put in place by the DSA will stand the test of time, if not forever, but hopefully for 20 years like the e-commerce directive.
Okay, good answer. Now you mentioned there due diligence measures, and there's a couple of things I want to touch on just in our last few minutes. And the question is whether conditional liability should be linked to compliance with due diligence measures. Matthew, do you want to mention that? And I also then want to touch on very briefly as well the questions of passive intermediaries and what should be obligations there. So I'll let you take that away, Matthew.
Thank you, Jennifer. I mean, this is a really tricky question, I think, and it my answer, which is a bit of an evasion, bit of a dodge, but I hope you think it's fair, is that it needs more considerations. This is the notion that you have sort of conditional non-liability almost. The concern that we would have is that it does seem to link two things that are not necessarily linked, actually. Compliance with the obligations versus kind of actual knowledge or complicity in illegal activity on the site. And, you know, the two things are logically distinct. You can understand why you might say if you don't comply with the DSA, you become liable. But the benchmark traditionally in law has been acquiring actual knowledge is the way that you could actually assume liability, which seems to be the more legally coherent, logical and sound basis. So there's certainly merit in having the discussion and understanding if there's something we can pull from that idea, but I do definitely think that it's it requires more reflection. I think you also invited a comment on the notion of passive versus active service providers, which is again a very hotly contested kind of discussion that's been had around the e-commerce directive for a number of years, and significant that the Commission did not really address this in its legislative proposal. And as I mentioned earlier, I think the criteria that's used to decide when additional obligations should apply in the Commission's proposal is based on risk assessment, which is size, dissemination to the public, rather than trying to say, you know, passive service providers have one set of obligations, active service providers would have another set of obligations, because it's so difficult to really nail down where that distinction falls. I would say that has led to potentially a few problems in the ongoing drafting process and scrutiny by co-legislators, where it becomes very easy at the sort of stroke of a pen to change the scope of the proposal and to extend the due diligence requirements to a whole additional set of online intermediaries, which would not be possible if you kind of really created a firewall between passive and active services and said up to this point certain obligations apply, above this point different obligations apply. So by not addressing this, I think you do keep this discussion live, and it probably will continue into the future as well, with subsequent you know, opinions and rulings from the European Court of Justice as well. So I think completely understandable, and actually you get to the same end point with the Commission's proposal, but it does mean that discussion will rumble on. Maybe just this might be my final comment, Jennifer, just to respond to the previous question, which I think is a really good one on having a regulation that's future-proof and will survive another 20 years. For me, the real litmus test of that is actually what the DSA doesn't say rather than what it does say, which is, for example, that it doesn't include mandatory strict takedown time limits for certain forms of content, which could quickly become outdated and could lead to then kind of interjections and additions from, you know, other stakeholders who have different content that they're looking to police. And that in itself is one of the things that makes the file future-proof. The other is the fact that it steers away from really kind of prescriptive forms of content moderation, so mandating kind of upload filters, algorithmic content filters, etc. Again, which could become outdated very quickly. So really the test of this being a future-proof file is almost what it doesn't say rather than what it does say. But again, I think you know, we've been very praiseworthy of the Commission proposal so far, and I'm not going to stop now. So yeah, that really is to be welcomed.
Thank you. Irene, as we are drawing to a close, perhaps I could get your reaction to what Matthew was saying about passive intermediaries and a sort of maybe wrapping up takeaway comment or two.
Yes, indeed, this was one of the origins of the increasing legal fragmentation that we were observing when we decided to present the new proposal. So I think we have seen in some member states, and in particular in Germany, some curious situations where a platform was declared to be active in order to ask them to act diligently. So we decided that it was more reasonable to directly request this due diligence that they have to comply with regardless of the liability, which is a case-by-case assessment that might be different from one listing to the other. So all the discussion around active and passive at the end of the day has to be left to the case-by-case assessment, which is not a solution for anyone, not for the platform, because it does not create legal certainty, nor for the rights holder or the user, because it will have to litigate to determine whether it played actively or passively for that specific listing. But at the end of the day, we will get the result elsewhere, and we will be sure that that platform will need to act diligently. This is also a reason why we did not want to make any conditional link between liability and responsibility, even if it might sound attractive, you know, at first sight. Say, wait, you have to comply with those obligations. So if you don't receive this kind of privilege. First, we don't think it's a privilege. It's a harmonization of tort and criminal law. And second, it would make life of national judges quite difficult. Let's imagine that there is a good sold in the eBay and someone goes to court because the eBay did not take the content down when it received the notice, etc., and then that judge has not only to determine whether it acted expeditiously or did have actual knowledge, they also will need to go to eBay and check one by one whether they were respecting all due diligence obligations. And for instance, eBay might have respected the know your business obligation for one specific trader, but not for the other. So it would be a legal trap. So this was the reason why we did not consider it necessary to create this link. And as regards the question on possible over removal led because of the specific timelines for removal, this has been the position of the Commission from day one. This is a horizontal instrument. This is not the place to determine what expeditiously means in all cases. This is a case-by-case assessment. We have in sector-specific measures, we have specific deadlines. The last case is in the General Product Safety Regulation, where we propose 5 working days. And obviously, this needs to be proportionate and tailored to the kind of illegal content and the type of service provider that we talk about.
Thank you very much, Irene, for really clearly explaining the position. Sally, last word goes to you before we wrap up. Closing comments or thoughts based on what we've talked about today. I'm afraid you're on mute.
I mean, we couldn't get through without that happening once. So, well, I think, you know, if anything, the DSA has just opened up some very important questions. And I'm looking forward to seeing what the final result of the legislation is. But even more so, I think, is going to be after the fact, then when the Commission is producing guidelines on what systemic risk actually means and what these different things happen. And that's going to be very interesting, interesting space.
But thank you very much, Sally. As we say in the newspaper world, this one's going to run and run. I think we'll still be talking, no doubt, in a year or two's time. Thank you very much to all my speakers for your input. It's been lovely to talk to you. I also want to thank again Peter Geršak from the Office of Digital Transformation in the Slovenian government, and of course to GIGAEurope for organising today's event. I hope we've had a fruitful discussion. This is part of a series of events, so please do keep your eyes open. We're going to be discussing all these issues and the question of connectivity and trying to achieve the aims that we've seen set out to digitize the EU, to build back better. So thank you very much and have a great day.